Item 6, 7, and 8. Meeting on 6, 6th of December.
6, 7, and 8.
Well,
Both sides are represented. List after a week. As per by 11 council for the petition. Okay.
May I please, my lord, item number 15, my lord. This matter will be taken on next Monday, my lord. Today
15.
I have some 15-1-5, my lord.
Okay. Same here. Same order. 15.
May I please, Lordship? My lord, I have prayer for upgradation of a matter, my lord. Item number 32, my lord. This man was arrested on 21st of September. Now she will kindly fix at 2 p.m. my lord, if possible.
Item
32, my lord.
32.
Admission matter, my lord. The LCR is also available, my lord. Today, my lord, LCR has come, my lord. My lord will kindly take at 2 p.m. my lord. He's in
Okay.
jail, my lord. Deeply available.
Yes.
Item 31 also, my lord. Item 31, my lord. Man is in jail, my lord. Detention center, my lord. So that matter may be taken at 2 p.m., my lord. LCR is also there, my lord.
Okay.
At 2 p.m., my lord.
Listing of this. Single to the court master.
May I please, Lordship? I beg to mention item number 3, Lordship.
3.
3. Lordship, can you pass over the matter forward there, Lordship?
Item 3. Same order. After a week.
Lordship, in item number Lordship 39, Lordship, we are supposed to file affidavit, Lordship, but due to some official inconvenience, Lordship could not file, Lordship. And maybe next Wednesday, Lordship.
Lordship, in this matter, my lord, Mr. Sikdar is appear, my lord. Today, my lord, Mr. Sikdar will appear, my lord. And in the matter, my lord, this is the ex parte order, my lord. No notice has been served, my lord. Lordship is maybe granted bail and remand back the matter to contest the same, my lord. The record shows that no notice has been served.
But here there's a name.
Lordship.
Yes, Lordship.
Yes. So they were required to tell us whether the two persons are same or not.
Yes, Lordship. On earlier occasion, Lordship, we have placed our instruction, Lordship, but Lordship directed to file affidavit, Lordship.
Since 2/9, my lord, is
Okay, do it by Monday.
Yes, Lordship.
Okay. Both sides are represented. Mr. G. Sharma, Learned Standing Counsel for the FT matters. Pays for some more time to file affidavit in the matter. Let the affidavit be filed within 2/12/2024. List on 4/2/2024. 4/12/2024. It is made clear that if the affidavit is not filed, the matter would the prayer for bail shall be considered on the basis of materials available on record.
Upgraded item 37.
may I please? My lord, this is from a registration of my lord. WC number 4864, my lord, which are disputes for non-prosecution on 12/7/2024, my lord. Initially, my lord, we filed in this case, my lord, data was withdrawn, my lord, with liberty. Subsequently, my lord, this case has been filed. My lord.
কিহৰ কাৰণে মিষ্টেক কৈছে?
What was the issue here? Why did you withdraw it? There was
My lord,
some defect here.
well-
What was the defect?
my lord, actually, the reasons why I could not appear was not properly explained in earlier.
It was not explained.
One.
Yeah, you see, we are restoring it on only looking at the petitioner. But the explanation tendered is absolutely unacceptable. Because so far as my personal experience is concerned, I have never found any honorable judge in this court who, after the matter is dismissed and a mention is made, he has not restored it and he or she has not restored it and taken it up. You say that the council went to the bathroom and came and then found that the matter is dismissed. If that is so, it could have been mentioned. Then the lawyer, you are the lawyer,
My lord,
you conveniently. Hmm? Yeah, that's right. You conveniently walk away. This exposes your casual approach. You know that matter is dismissed and you walk away. Either it is total disrespect for the court or you don't care.
actually, my lord, on that day I was not feeling well, my lord. That's why.
No, you see, there are hundreds of friends of yours. But if you don't have a single friend in the bar,
My lord, that is on my.
you are an unfortunate lawyer.
I am admitting, my lord, that's my fault. On any terms and condition, my lord.
You see, you have seen the council in the treasury side, for the FT for the government. Even if you tell them, they will make a mention. There's so many cases where the council, for some reason, they tell them and go out, and we accommodate.
Yes.
It's not that we don't take an adjournment prayer on behalf of the petitioner from the treasury side. We never do it. If you're a practicing lawyer here and you don't have a single friend to make a mention, even if when you are unwell, we can only say sorry for you. It's never happened. You give a you give a ground which you have never heard. It's only for your petitioner that we are restoring it. You hold a brief and you say you feel you are not feeling well and you walk out of the courtroom. It has never happened. For me, the council with whom I don't have any relationship, even if I tell them when I was there, they would make a mention. Even if they are not friends, we know each other by face. They just tell them this is my problem and everybody accommodates. Okay. But Mr. J. Islam Leonard, counsel for the applicant, for the petitioner, also heard Mr. G. Sharma, Leonard, standing counsel for the FT matters representing respondent number 2 and 4, 2, 4, and 6.
Yes, sir.
And Mr. P. Sharma, an additional senior government advocate appearing for respondent number 3, and Mr. H. Kudi, learned counsel for respondent number 5, Election Commission. We are appearing for AIRB. We are for
Yes.
AIRB. Next one. Here in this case is for restoration of WPC 4864 of 2018, which were dismissed for non-prosecution by order dated 12/6/2024. So the ground for the explanation for the default in appearing of the appearance of the Learned Counsel on 12/6/2024 is that he had gone to the washroom and by the time he came back, the matter was dismissed for non-prosecution. Full stop. It's further projected that he was unwell and then left the court. Full stop. The explanation is totally unacceptable, as it has never happened that even after dismissal, if the learned counsel immediately thereafter comes and gives an explanation, then the matter is not restored to file. Full stop. Moreover, there is absolutely no explanation as to why the petitioner remained unrepresented when the matter was when the writ petition was previously listed on 7/6/2024. Full stop. The conduct of the learned counsel for the petitioner in non-appearance when the matter is called is required to be deprecated. Full stop. It is only it is only for the reason that the issue of citizenship is in challenge in the present writ petition, in the connected writ petition, comma, that being a valuable right, we are inclined to restore the writ petition to file. First of however, at the same time, we are inclined to impose a cost of rupees 1,000 on the learned counsel for the petitioner to be deposited with the welfare fund of the Guwahati High Court Bar Association. Stop. Next para. The said payment shall be made within 2 weeks from the date of the order, and receipt of such deposit shall be produced on when the writ petition is next taken up. Stop. The restoration is ordered subject to payment of cost, and therefore non-payment shall the non-payment thereof may result in the revoking of this order on the next date of listing. Next para. The is at the giving not from the petitioner, not from the petitioner. So subject to the condition as indicated above, comma, this case stands allowed, despite objection made by the learned standing counsel for the FT matters. And in the writ petition, you say that in view of the conditional order passed today in MC 79 of 2024, this writ petition stands conditionally restored to file, restored, list the matter after 3 weeks on a date to be fixed by the registry. Do we have the record?
Record was sent back, Lordship.
What could be? Huh? In the manner in where the registry shall call for the relevant records from the concerned tribunal. You have restored it at a cost of rupees 1,000.
Highly placement. One small prayer, my lord. Earlier, there was some protection. My lord.
We will say list it after 2 weeks. We'll let the records be recalled.
Highly obliged.
Item 40 upgraded for orders.
May I please, Lord?
Yes, sir.
Lord, Mr. Action was called from.
Yes, you have instructions.
Lordship, I
In
don't.
this case, they projected that the mother of the SP border had expired. He went there to take bail. could
Oh,
not.
no.
So we wanted instructions from you.
Lordship, day after tomorrow, Lordship.
Day after tomorrow. Take information because if he has, if the mother has expired
Yes, Lordship.
during that period, then he has a ground to be
Yes,
for
Lordship.
extension of the order.
Yes.
Okay, both sides are represented on the prayer made by Mr. G. Sharma and standing counsel for the FT matters. Comma seeking time to obtain instructions as per order dated 28/11/2024. All the matters stands adjourned today. This one. 29/11/2024. 29th.
Daily list item 1 for motion.
Mr. Sharma.
Lordship.
Mr. Sharma, there is a criminal writ petition here. We see it from the cause list.
Yes.
This is item 36. Just take note of that. You. So that's why before we rise, we'll take up this matter. We are just telling you. No, not now, but we'll take it up this matter. At the appropriate time, we'll take it up before rising.
May I please, Your Lordship?
Yes, Mr. Barbuya.
May I please, Your Lordships? Last occasions, Lordship, I took time on the ground that similar notice issued to his father also, that case was pending. As per information, Lordship, father expired and tribunal already passed order for abating the case, abatement order passed because person expired.
Okay.
So here is the case. I'll go for the present documents, Lordship, which I relied, petitioner relied in the tribunal, Lordships. The impugned order is at page 41. Order is dated opinion 17/7/2018, page 41. Short order, Your Lordship, if I permit me to read. Here I exhibited documents 1 and 2, Lordship, land revenue is 1 land revenue receipt, where my
Who are your witnesses?
witnesses, Lordship, here find only the petitioner, Lordship,
The petitioner.
only the petitioner. And I submitted written statement also, Lordship, and from the records, Lordship, more certified so it appears that they did not appear, Lordship, and the tribunal cross-examined, Lordship, member, which is also not permissible, Lordship. In the opinion also, so none appeared for the petitioner, that means prosecutor. Exhibit 1 is the land revenue receipt, where my grandfather's name and grandfather's brother's name appeared in the exhibit 1, Lordship, that I annexed in the present proceeding, this petition, Lordship, annexed 6, page 16. And exhibit
You see,
2,
your evidence is very strange.
Yes, Lord.
It doesn't inspire confidence of the court. You see, you somewhere have said that you have your mother's death certificate, but you don't know when she died. You don't know where you were born.
Lordship,
You merely say that from
Why-
childhood
why
I
are-
am living there.
Lordship, here
That is
the
something which is impossible.
question is that date. state
No, no.
cannot be,
You are-
person is illiterate.
No, no, in your evidence you say.
Yes, I have seen
I don't know where I was born.
where I was born. Lordship is correct. Because after childhood is not, maybe hospital or the house may not be known. It was not disclosed to the parents.
I don't know.
In the
you see,
house or
this
hospital, he is
is
correct.
something very strange because
But-
when I look
But
upon,
subsequent statement,
no, you see,
excuse me,
let me,
subsequent statement from childhood, I am deciding.
no, you see,
From
it's
that
very
is the
strange
statement.
because of the fact that so far as I am concerned, my parents told me who were the doctors who had attended during my birth, and I know them by name. The midwife who was present at that time, I know her name. Because this is something which my parents
Yeah.
told me to, I was inquisitive and these things were asked and then my parents told me.
It's certainly.
And-
We are literate, Lordship. We put the
Until-
questions to our parents.
Till these
Yes,
people
we
were,
put it.
till these people were alive, my father maintained relationship with them.
No, we are literate. Certainly we put the questions. Everybody, Lordship. Here is his last sentence is I am illiterate. Since I am illiterate and as I do not know what is written in that's Lordship to be taken note, Lordship. The bottom say I am illiterate. Which year he says certainly correct, Lordship may not be. When my mother explained, when my mother, when I was reading class, here I have also cannot say also. Now,
This is an issue of citizenship. If you don't know where you were born, there's a presumption that you were born in Bangladesh.
from childhood, he is residing with his father, with that residence, Lordship, and corroborating the documents, his name with his father and grandfather's names appear in the voter list. That address is same. That presumption can be drawn, Lordship. If no other document is there, Lordship certainly is correct. But here the document is available.
No, you look at your cross-examination.
Cross
You don't know
examination.
the contents of the document. You don't know.
Actually, no
you
cross
did not-
examination.
You did not know whatever it be, but you don't know about the documents. You say that they've been procured recently.
জমা দিয়া কাগজবোৰ কি লিখা আছে নাজানো লাষ্ট ল্যাঙ্গুয়েজ 40
Here is the Lordship's state also not denied. Here the tribunal put question, member put questions to it.
That's okay, but
Yes, Lordship.
he
That is
wanted
also
to
not
know whether you know
participable.
the documents. He says no.
And documents, Lordships may be looked into since 1961 documents, Lordship 63
So if
documents,
the witness does not know about the document, why should?
and the voter list, but his names appeared along with his parents, Lordships. And earlier documents, his grandfather's document, Lordship, that is address is same. Even certain doubt, Lordships, in the Muslim model says the search the truth. Since it is a citizenship, Lordship concern. The documents corroborated the Lordship address, everything's contents. Conservative part 3 documents, Lordship from 66, the original residence also. Whether that person is concerned on that is also the question, Lordship. Even Lordship, I clarified my parents' name also, same and one person, tribunal held. I have not clarified that. And voter list held, it is certified copy is not true.
We are sending you the records.
Lordship,
Did you examine the records before arguing? No.
Lordship,
That is the difficulty. You are always saying that please look at the records.
I have not seen.
You see, if we do the exercise,
Lordship.
then we pass the orders. Why we need assistance of the lawyers?
Yes,
If you- Mr. Sharma, you also look into it. Come to page 47 of the trial court record. You see, this is the affidavit.
Lordship,
None of the exhibits below are even signed by the tribunal. So there is no evidence at all. It appears to us that many lawyers think that going to trial court is a very small work.
Person concerned submitted, produce the documents.
Then if you're, if you
Duty
don't
of
know
the
how to handle
tribunal
a trial,
sign,
how to handle the
taken-
trial. The lawyer who is conducting lawyer does not know how to handle the trial.
Yes, sir.
None of the exhibits are signed,
Yes, sir.
then there's no evidence at all.
Your Lordship, but tribunal also mentioned these are the exhibit. The duty of the tribunal also put signature all the exhibited documents. That may demand since the documents we I produced, that is not denied, Lordship. So, tribunal also says these are the exhibited documents.
You have the original documents with you?
That documents, Lordship, photocopy I have annexed in my.
No, not photocopies. Original do you have?
I have checked. Exhibit 2 is original, certified copies.
Okay, we'll take it up the
Certified
hearing
copy
in
with
2
me,
weeks.
Lordship. Just the certified copy.
You have it.
Yeah.
We will take it up after 2 weeks. Let me issue a notice. We'll issue a notice and then take it up for disposal. Also, it's duly represented. The trial court records, which we called for, is received. Next, matter requires some determination, examination of the records. So accordingly, issue notice returnable forthwith without requiring any steps to be taken by the petitioner. Next para. List the matter in the admission column after 2 weeks. The, as an interim measure, the petitioner shall appear before the Superintendent of Police within bracket border, Bongaigaon, within 10 days from the date of the order, and furnish a bill bond of rupees 5,000 with one surety of bank amounts and default clause. If non taking a bill, shall understand when we vote.
Obliged.
Item 2.
Oh, no, there's already an order. He shall not be arrested, not required. Interim order custody stands extended to the next.
May I please, Your Lordship? I am on behalf of I Hussain on instruction, my lord. He was late, my lord.
My lord, since 2018, lordship, this case was going on. like this way, Lordship. Till that notice has not been issued, Lordship.
Both sides are represented. On the prayer made by Royal Council for the petitioner, matter stands adjourned for a week. So it is made clear that if the petitioner that no further prayer for adjournment on behalf of the petitioner shall be entertained on the next date. And if such a prayer is made, adverse orders may follow. That's for a list after week. Next time, if you make a prayer like this, we'll dismiss your petition.
Mobilize.
Item 4.
Okay, let's see this first. Item 5.
May I please your lordship? The matter may be passed over for time being. My senior is lagging another call.
Yes.
Item 9.
May I please your lordship? Your lordship, this is a contested matter, your lordship. And order is at page, your lordship, 32, your lordship.
What is the best document to connect you to your projected parents?
Your lordship, I have documents of voter list of 1996.
No, apart from voter list.
Your lordship, there are few land documents. A land document of a certificate of is in page 83, your lordship.
Page
83, your lordship.
83.
Which is the name of the father of the petitioner, Sobed Ali. And
This document does not help you. It's a recent document of 2009.
yes, your lordship, it's a recent document. Basically, we have the petitioner to establish a linkage with the father and the grandparents are the voter list, your lordship, which is of 1996 and 1970, your lordship. In the voter list of 1970, which is in page 69, your lordship. Fifty-nine seventy, your lordship. In the voter list of 1970, your lordship, the name of the father, grandfather and grandmother is there, is mentioned.
What is the petition name? Johanuddin.
Jahanuddin, your lordship. Jahanuddin name will be is available with his father and both the mother is at page 75, which is a voter list of 2005, your lordship.
Come to page 70. Who is the father, projected father?
Sober Ali, your lordship.
And
Then
petitioner is serial number 2.
petitioner is Jahanuddin, your lordship, which is mentioned in the, which comes along appears in the voter list of 2005, your lordship. Which is at page 75, your lordship.
Ms. Endekal and the counsel for the petitioner. Also heard Mr. G. Sharma and its standing counsel for the FT matters representing respondent number 2, 4, 6 and 7. And Ms. P. Sharma and its additional senior government advocate appearing for respondent number 5. For Election Commission, who's there?
Yeah,
Yeah, standing counsel for respondent number 3. And filing this writ petition, opinion dated 5/4/2024. Which page is the opinion?
Opinion is in page, your lordship, 32, your lordship.
Right for 22, passed by so and so and so and so. Is assailed in this, thereby declaring the petition to be a foreigner of post 25/3/1971 is assailed in. No, not 1921, 71. You should notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the CEC, State and Department Council within 2 days. That the relevant records be requisitioned from the consent tribunal. The petitioner shall appear before the Superintendent of Police Border, Dhubri,
Yes, your lordship.
within 10 days. Below ₹5,000 with conditions. If the petitioner does not appear, order of bail shall stand lapsed by course of time. 10 days time to take bail.
The plea applies.
This after 4 weeks on receipt of tribunal records.
Item 10.
Yes. Also, here in this case, Lordship, she has right on the documents of her father, Lordship. Her father's name is in the voter list of 1966, Lordship. That is
First
at
of all, what
page,
is the explanation for 1 year's delay in approaching the tribunal?
Lordship, that is at page para 20, Lordship, page 20, para 18, Lordship.
Page 20.
Yes. For 6 months, Lordship, after the, she couldn't not hire an advocate, Lordship, for her poverty. And after that, Lordship, the other counsel, Lordship, who is in this case, he met with an accident. And he kept the file for 3 months, Lordship.
Okay. And what is the best document to connect you to your parents?
That's
Don't show us voters list
no, Lordship, the
or the Gabura certificate.
apart. There is no such document, but the brother has adduced evidence, Lordship.
Brother,
Yes, the step brother.
where is the deposition of the brother?
Yes, Lordship, I'll take Lordship to the cross-examination of the brother, Lordship. His evidence in page 55, Lordship.
Where is your written statement?
Yes, Lordship. Lordship will find the written statement at page, it starts from page 26, Lordship.
26. Your brother is disclosed here.
Yes, yes, his name is there, Lordship, in the written statement. Para 10, Lordship. At 27, page 27, para 10. Second party has two step brothers, namely Hanif Ali and Altaf Ali. And Hanif Ali deposed, Lordship.
But the identity of your brother was never proved. There's no way you can connect yourself to your stepbrother.
That statement is there in the,
Statement is not enough.
and he has exhibited one document, Lordship, I think. It was, it's not annexed here, Lordship, but
Then
that is. Exhibit key, I think, is voter ID card.
there are so many celebrities. People may like to have them as their brother and sisters. Anybody coming and saying that he's the brother, will it be sufficient? Is it due explanation of the parameters of section 50 of the Evidence Act?
People there carrying one voter ID card, Lordship, that was exhibited, I think.
Oh, how many judgments we have in our court to say that voter identity card is not a proof of identity? It's not a proof of parentage, it's not a proof of relationship.
The difficulty, Lordship, they get married, Lordship, prior to attaining the age of.
So there's no connect, everything there is a disconnect. You can only say that you will be not deported. It's not a case of bail.
And the DW3 has also deposed, Lordship, he is the Gauvila, Lordship.
Heard Mr. M. Ahmed and counsel for the petitioner. Also heard Mr. Ms. L. Devi Leonard, CGC for respondent number 1. Mr. A.I. Ali, that's standing counsel for respondent number 2. Mr. G. Sharma, Leonard, standing counsel for the FP matters representing respondent number 3, 4,
5 and 7.
5 and 7. And Mr. P. Sharma, Leonard, additional senior government advocate appearing for respondent number 6. Page 67. Opinion dated 18/9/2023. Passed in so and so arising out of IMDT reference number so and so by so and so. Notice extra copies within 2 days. Call for the records. Next one. Considering the projection made by the petitioner that she is aged 67 years of age, it is provided that the petitioner shall appear before the Superintendent of Police, Border, Borpeta, within 10 days, bail of ₹5,000. With conditions, and in default, the order shall be revoked. And call for the records also. Giving a bail considering the age,
I oblige, Lordship.
you're not satisfied at all.
11.
Your prayer of bail shall be considered on receipt of the records. It is 4 years of delay, you have not explained. That explanation is not acceptable.
Lordship, petitioner is a from very poor family. We are doing pro bono, Lordship.
Please understand that that is not acceptable for the purpose of bail.
petitioner has sufficient documents, lordship. He has submitted all his documents, lordship.
But this delay of 4 years. It's an entirely due to protection. We'll consider it on receipt of the records.
Lordship, actually, the petitioner is from very poor family. So
We understand that. But for 4 years, there is no explanation. You say that you are doing pro bono. So that time nobody stopped them from approaching you. But for
recently
4 years, the
petition
delay is
was-
unexplained. It's okay, but 4 years, it's not your fault, but 4 years of delay, you can entitle you to protection immediately.
Let the
But Miss
A. Hussain, lordship.
A. Hussain, and counsel for the petitioner. Also, Ms. L. David and at CC appearing for respondent number 1. Mr. G. Sharma, and that's standing counsel for the acting matters representing respondent number 2, 4, and 6 and 7. And Mr. A. I. Ali, standing counsel for respondent number 3. And Mr. P. Sharma, and additional senior government advocate appearing for respondent number 5. Filing this repression under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 36/2020, page 28. Passed by so-and-so in BFT case number so-and-so, rising out of FT case number so-and-so. They were declaring the petitioner to be a foreigner of post 25/3/1971. Notice extra copies within 2 days. Call for the trial court records. The records of the tribunal, which the prayer for bail shall be considered on receipt of the records of the tribunal. Next, power comment is provided that in the event the petitioner is apprehended, he shall not be deported without an order of the court. List. Give a date after in the month of January, because we are not giving bail. We turn up on so and so, give fixed date. We'll give a fixed date after some time.
Much of that.
12.
May please, your lordship.
Yes.
My lord, here in this case, my lord,
What is the best
Gan-
document?
grandparents are voted in 1959, my lord.
And apart from voters,
Yes.
what is the best document to connect with them?
My father was examined.
Your father was examined.
Father was examined.
Where is his evidence?
Now, my lord,
In the
DW2,
in the written statement, have
and-
you introduced your father?
yes, my lord. Yes, my lord. His DW2 is at page 73. And father is voter with grandmother in 89. And father was examined.
Okay. But Mr. A.R. Sikdar Lanet, counsel for the petitioner. Mr. Yes, the council, council to the petitioner. Ms. L. Leonard CC, appearing for respondent number 1. Mr. G. Sharma, Leonard standing counsel for the FT matters representing respondent number 2, 4, and 6. And Mr. A.I. Ali, and the standing counsel for respondent number 5.
Your Lordship.
Oh, you are there, Ms. S.T. Khan, Leonard counsel appearing on behalf of Ms. P. Barwa, standing counsel for respondent number 5. And Mr. P. Sharma, an additional senior government advocate appearing for respondent number 3. But
My lord.
Mr. Sikdar, you'll have to update yourself.
My lord. Yes, my lord.
You have seen respondent number 3.
That's one number 3.
It does not exist.
Deputy Commissioner, yes, my lord. It should be District Commissioner, my lord.
Yes, so you have to upgrade yourself.
My lord, my lord.
You have a cane in your house, no? Because when we in the school, when we make mistakes, we had a cane with our teachers, even if they don't scale us, but still that was a fear.
Yes, in some petition written District Commissioner, but here we committed mistake, my lord. This one petition of the District Commissioner very safe.
Because my esteemed brother is also amused because of the fact that in all foreigners' cases, names change very frequently. But this is a case where respondent number 3 is by gazette, his name is changed. So you'll have to give a fresh cost title.
My lord, I'll furnish a cost, fresh cost item.
Let's see. Next para. As the office of respondent number 3 does not, no longer exists, the learned counsel for the petitioner shall provide freshly typed copy of the corrected cost title in this, specifically in respect of respondent number 3 before the AOJ, FT section within a week from today. It shall be incorporated in the records. Next para. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 10/9 to 2024 passed by so-and-so in case number so-and-so arising out of SP border reference number so-and-so. By which the petitioner has been declared to be a foreigner post 25/3/1971. Expectation notice returnable in 4 weeks. Extra copies within 2 working days. Then the records of the tribunal will be called for. The petitioner shall appear before the Superintendent of Police, Border, Bishwanath within 10 days below ₹5,000 with those conditions and default condition. List after 4 weeks on receipt of Calcutta records.
Deep level.
Item 13.
Lordship may pass over the matter for time being. Senior counsel is in court number
Time
19.
Yes, 14.
May I please your lordship?
Here, what is the delay? How do you delay? How 2 years is explained?
Your lordship, because of her poor economic condition, your lordship, that has been mentioned in the paragraph 42, your lordship. The petition. She's a housewife, the petitioner is a housewife, your lordship, and due to her financial scarcity, your lordship, she could not approach before this honorable court, your lordship. And for that reason, there is a delay of 2 years, your lordship.
But she has a father, she has a husband, she has a family.
Her father died, your lordship.
What is the best document to connect you to our projected parents?
Your lordship, there is a Kabilnama, which is in page 135, your lordships.
Exhibit 11.
Yes,
Did
your,
the Qazi,
exit
did the,
17, your lordships.
did the Qazi come and depose?
Yes, your lordships.
Where is his evidence?
Yeah, it's a DW3, your lordship, it's page number 102, your lordship.
Point 36 অনেকে জোটে পেজে ডাটা আছে হ্যাঁ
You know, I have some prejudice which I'll express. If there's a bad economic condition of the petitioner, lawyer drafting 32 pages of writ petition.
Your lordship, this
This-
because of the fact.
Just doesn't match the economic condition.
Your lordship, we are providing pro bono legal aid.
No, that is okay. Providing pro bono is okay, but 32 pages of writ petition, which could have been otherwise drafted in, you have seen the written statement. It could have been economically packaged, but that was not done. We have some prejudices. But and Dekar and counsel for the petitioner. Which page is the opinion?
Your lordship, page 34, your lordship.
34. I think this repetition and Article 226, or you just say, you can take the petitioner. Mr. Also heard. Ms. L. Devil and CGC appearing for respondent number 1. Mr. G. Sharma and its standing counsel for the FT matters representing respondent number 2, 4, 6, and 7. Mr. H. Kuli on behalf of Mr. AID, standing counsel for respondent number 3. And Mr. P. Sharma, an additional senior government advocate, appearing for respondent number 5. Filing this repetition under Article 226 of the Constitution of India, petitioner is in the opinion dated 19/4/2022, page 34. Passed by so and so in case number so and so arising out of police reference, case number so and so. By which the petitioner was declared to be a foreigner of post 25/3/1971. Issue notice returned within 4 weeks. Extra copies of the petition be served on the grounded CEC, State and Departmental Council within 2 days. With the relevant records be requisitioned from the concerned tribunal. Petitioner shall appear before the Superintendent of Police Border, Dhubri, in 10 days, maybe conditions. Default was also, only in case of non-appearance, 10 days time to take bail. This
Should
topic
be
from
obliged,
the
sir.
civil tribunal records.
Item 16.
We are not giving you bail. It's a 2021 matter. Your delay has not been explained. It will be considered on receipt of trial court records. But Mr. S. J. Sharma, the counsel for the petitioner. Mr. Also heard. Ms. L. Devi, the CEC appearing for respondent number 1. Mr. G. Sharma, the standing counsel for the FT matters representing respondent number 2, 3, and 6. And Mr. P. Sharma, the additional senior government advocate appearing for respondent number 4. And Mr. H. Kuli, and counsel on behalf of Mr. A.I. Ali, and counsel for respondent number 5. Which page is the opinion?
Opinion was page lordship. 16 lordship, annexure 1 lordship.
Filing this repetition on Article 226. Petitioner has assailed the opinion dated 8/3/2021, passed by so and so in case number so and so, arising out of reference number so and so, by which the petitioner was declared to be a foreigner of post 25/3/1971. Issue notice, extra copies within 2 days. Call for the records. Explore the as the there's the delay in approaching this court. Is not properly explained, the prayer for bail shall be considered on receipt of the records of the tribunal. However, comma, it is provided that in the event the petitioner is apprehended, comma, he shall not be deported without the order of the court. Next paragraph is one. Give a fixed date. We are not giving bail. Give a fixed date in the matter. Notice written on 8 January.
Item 17.
Yeah, please, your lordship. My order impugned is at page 39. There are, my lord, documents to show.
What is the best document apart from voter list?
My lord, apart from voter list, my lord, there is a patta. My lord,
Which
issued
page?
page 33, my lord.
33.
Page 33, annexure 7.
It was exhibited document.
My lord, that is what, my lord, not done by the my lord, the petitioner. My lord, he went, my lord, time and again to the court. But, my lord, unfortunately, my lord,
No, this
he-
photo would not help you. This is a 2005 document.
True, my lord. But prior to that, my lord, the linkage document which, my lord, I have submitted along with my written statement, my lord, before the learned tribunal. My lord, that is 1966 voter list, my lord, wherein my father's name.
No, you
my
see,
great-
this will not help you because of a reason that the inquiry started in the year 1998.
My lord.
Thereafter, you have this pata.
My lord, this patta is, my lord, in the year, yes, 2005. 2005.
That's why it's a post
My lord,
inquiry document.
It's post inquiry, absolutely, my lord. But prior to that, my lord, it is a fact that, my lord, I was born in the village, my lord, of the under Titapani, my lord, Borpeta district. And my father, my lord, Abdul Mia, whose name is appeared in the voter list, my lord, 1966. And my grandfather, my lord, Badsha. Then in the year 1970, my lord, 1970, your lordship will find, my lord.
No,
my
you
father's
just
name-
first please concentrate on the documents you have exhibited. Because we are not finding.
My lord, evidence on affidavit could not be submitted before the learned tribunal, my lord.
Then we
That
can't protect you.
that is, my lord,
Then we
of
can't
course,
protect you.
that is, of course, my lord, the fault of.
No,
of
Mr.
the
Sen,
engaged-
you see, when you are
My lord-
referring to a document, please tell us that this is a exhibited or unexhibited document.
My lord,
Unnecessarily, we take the trouble of reading and then finding it out it is not exhibited document. Then you tell us that
my lord, it was,
evidence read.
it was not exhibited, my lord, the evidence on affidavit in support of the, my lord, the document that has been filed in the, along with the written statement, that was, my lord, unfortunately not exhibited, my lord. That
So we
is,
can't
that is,
protect you, we'll just issue notice.
my lord, your lordship kindly
bail-
consider, my lord, he is elderly person and everything is there, my lord. His
We
patta
can't
is
help it
there.
if there's no
Patta is, of
document.
course, post, my lord,
If
investigation.
you have not exhibited any document, we can't help you in
That
any
is,
way.
that is, of course, my lord, fault on the part of the engaged counsel, my lord, appearing in the,
So see, we
before the
will
learned
examine
trial
the
court, my lord.
records, then we will consider your prayer for bail.
My lord, he is suffering, my lord, elderly
We
ailments,
can't
my
help
lord.
it.
My
We
lord,
can't help it.
he requires, my lord, proper medical attention, my lord.
No,
My
that
lord,
is when you are apprehended, then only,
my lord, I have filed another application, my lord, as, which was registered as IA, my lord, stating all the
For?
facts for grant of bail, my lord. IA has already also been filed, my lord, in this case.
we,
My lord,
we'll
stating,
have to dismiss it. You file an appropriate application. Your application is under 389 of CRPC. We can't do anything. This
My lord,
filed an application.
as well as 227, my lord, that was also there, my lord.
227 also, we are not exercising jurisdiction under 227.
My lord, your lordship kindly consider, my
You
lord.
can't help it. No.
My lord,
You file an
otherwise,
application, appropriate application.
my lord, otherwise also he is suffering, my lord, so aged ailments, my lord, in the detention camp, my lord. His health condition is deteriorating day by day, my
So
lord.
that you
Well,
tell
that
us,
is-
we'll inform the authorities to take care of.
We have informed, my lord, but
Medical.
he was not properly taken care of, my lord. That is our grievance, my lord. Now, my lord, if he dies, my lord, our apprehension at the detention camp, my lord, that will, my lord, cause serious, my lord, prejudice to us, my lord. That
No,
is,
we
my lord,
can't help it.
your lordship, I have stated, my lord, in my, that he.
File an appropriate application. We can't entertain bail application under division bench cannot entertain an application under 389 BNSS.
Provisions of law may be, my lord, wrong, but ultimately, my lord, your lordship,
Mr.
my lord,
PK,
my lord, I have stated all the.
you see, Mr. Sen, please don't compel us to make statements which we dislike. Because if you make that statement, then we retaliate to say that we have a lawyer who does not study.
No, my lord,
Then don't tell us, don't push us to a corner where we retaliate, and it will be very unpleasant. We don't want to
I understand.
say anything in the court which is unpleasant, and
I'll file
and
proper
it
application.
changes
I'll
the
file
mood of
proper-
it changes our mood. You make us say a statement which we dislike.
My lord, I'll file proper application.
You first say 389, then say 227, then justify it. You do not say that you made a mistake. When you are pushed to a corner, then you give a statement, and then you say it's a mistake. Don't push us to that extent.
My lord, I'll file application.
Heard Mr. B.K. Sandran, counsel for the petitioner, also heard Ms. Aldeville and CEC appearing for respondent number 1, Mr. G. Sharma, and standing counsel for the FT matters representing respondent number 2, 3, 4, and 8. And Mr. P. Sharma, and additional senior government advocate appearing for respondent number 5, and Mr. H. Puli on behalf of Mr. A. Ali. For respondent was 6. Okay, 7 is also Mr. Sharma, senior government advocate. 7.
Election officer.
Page
Election officer.
election officer. Page 47. By filing this repetition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 19/7/2024, passed by the by so and so in case number so and so, arising out of reference case number so and so, comma, by which the petitioner was declared to be a foreigner or post 25/3/1971. The learned counsel for the petitioner has submitted that the petitioner has been apprehended and taken into custody on, what is the date you are taken into custody? What is the date when you were taken into custody?
My lord, 7/8/2024.
7/8/2024. Next plan. You should notice returnable on 8/1/2024. Requisite extra copies of the retribution be served on the landed CGC, State and Departmental Council within 2 days. Let the relevant Records be requisitioned from the Learned Tribunal. Next, prayer for bail shall be considered on receipt of the records of the tribunal. Next paragraph. However, in the meantime, the petitioner, who is lodged in the transit camp, Matia, Gwalpara, shall not be deported without the order of the court. Next paragraph. The learned standing counsel for the FT matters shall transmit a downloaded copy of this order to the transit camp, Matia, Gwalpara, so that the authorities take note of the order of not to deport without the order of the court. List on so and so. This IA, there is an IA, you say, heard so and so. As the interlocutory application for bail is made under the provisions of section 389 of BNSS, read with article 227 of the Constitution of India, the same cannot be entertained as the connected writ petition is under article 226 of the Constitution of India to assail the opinion of the Foreigners Tribunal concerned. Foreigners Tribunal number so and so. Next, accordingly, this writ petition stands. This interlocutory application stands dismissed for withdrawal with liberty to the petitioner to file an appropriate application.
May I please, Your Worship? Worship, Ibn opinion, my Lord, page 116.
What is the best document you have to connect you to your
Yes, my Lord,
projected parents?
page 115, school certificate, my Lord.
115 is a 2022 school certificate.
Yes, my Lord, headmaster.
How does it help you?
Yes, my Lord, page 111, my Lord, Kabin Nama also exhibited, my Lord.
Did this head teacher come and depose?
Yes, my Lord.
Where is
Page 87, my Lord, DW5, my Lord.
and which page is the opinion?
Yes, page, my Lord, opinion page 116, my Lord. My Lord, here my father and grandfather also adduce evidence, my Lord. This case, my Lord.
Father and grandfather?
Yes, yes.
Both?
Both adduce evidence, my Lord. DW 2 and 3, my Lord.
Okay. Heard. Mr.
I.H. Khan.
I.H. Khan, Learned Counsel for the petitioner. Also heard. Ms. LDV Learned CGC appearing for respondent number 1. Mr. H. Kuli on behalf of Mr. A.I. Ali for respondent number 2. Mr. G. Sharma and standing counsel for the FT matters representing respondent number 3, 5, 6, 7, 9. Mr. P. Sharma, an additional senior government advocate appearing for respondent number 8 and 10. Page 116. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 27/5/2024, passed by so and so. In connection with BNGN case number so and so, arising out of reference case number so and so. By which the petitioner has been declared to be a foreigner of post 25/3/1971 stream. Next paragraph. Issue notice returnable in 4 weeks. Requisite extra copies of the petition is served on granted CGC, State and Department Council within 2 days. Call for the relevant records from the concerned tribunal. The petition shall appear before the Superintendent of Police within bracket border, close Bongaigaon, within 10 days. Below 5,000 with all conditions as well as default condition. List after 4 weeks on receipt of records. 10 days time to take bail.
Yes.
Otherwise it will be
Oblige, sir.
lapsed.
Oblige, sir.
Item 19.
Yes, item 19. None appears on call for the petitioner. Heard. Mr. Ms. L. Devi Leonard CC appearing for respondent number 1. Mr. G. Sharma Leonard standing counsel for the FT matters appearing for respondent number 2, 4, and 6. As well as Mr. H. Kuli Leonard counsel appearing on behalf of Mr. AIRD for respondent number 3. And Mr. P. Sharma Leonard additional senior government advocate appearing for respondent number 5. Filing this writ petition under Article 26 of the Constitution of India. The petitioner has assailed the opinion dated 6/10/2023. Passed, page 28, passed by so-and-so in case number so-and-so arising out of case Jogi Gopa, IMDT case number so-and-so. Thereby declaring the petitioner to be a foreigner of post 25/3/1971. Issue notice returnable on so and so 8/1/2024 requisite extra copies of the petition be served on the learned CGC, State and Departmental Council within 3 working days. Let the relevant records be called for on the consent tribunal. The prayer for bail shall be considered on the next date of on receipt of the trial court records, the records of the tribunal. However, comment is provided that in the event the petitioner is apprehended, she shall not be deported without the order of the court. Next paragraph. List on so and so.
Item 20.
My lord, my sincere apology, my lord. I beg to withdraw this petition. We have made some inadvertent mistake, my lord.
Okay.
With liberty.
Mr. E.W. Amand, learned counsel for the petitioner, submits that there is some certain inherent defect in the writ petition, and therefore he seeks to withdraw this writ petition and to approach the court again. Full stop. Next paragraph. Ms. LDV learned CEC for respondent number 1. Mr. S.T. Khan, learned counsel appearing on behalf of Ms. P. Barwa, standing counsel for respondent number 2. Mr. G. Sharma, learned standing counsel for AFC matters representing respondent number 3, 5, and 6. And Mr. P. Sharma, learned additional senior government advocate appearing for respondent number 4 are present. This one, the prayer is allowed. The matter stands dismissed on withdrawal with liberty to approach the court again as prayed for.
I'm grateful, my lord.
21.
Near page, your lordship. Lordship, with the opinion at page number 58, your lordship.
Will consider your prayer for bail on receipt of the records. It's a 2019 opinion. But Ms. G. Bora, learned counsel for the petitioner, also heard Ms. LDV learned CEC appearing for respondent number 1. Ms. S.T. Khan, learned counsel appearing on behalf of Ms. P. Barwa, standing counsel for respondent number 2. Mr. G. Sharma, learned standing counsel for the FT matters appearing for respondent number 3
And 7.
and 7. You'll also appear for 5, I think.
5. No, Lord. Hey, P. Sharma.
Mr. Sharma, okay.
7, 6.
5. As well as Mr. P. Sharma, learned additional senior government advocate appearing for respondent number 5
6.
and 6. Next paragraph. Where is the opinion? Which page?
Lordship, 58, your lordship.
58.
Lordship.
we have to look into the opinion only for one reason. Why have you made respondent number 5 a party here? Why is respondent number 5 a party here? By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 1911-2019, page 58, passed by so and so in FT case number so and so, corresponding to SP reference number so and so, by which the petitioner was declared to be a foreigner of post 25/3/1971 stream. Issue notice returnable on 8 January 2025. Requisite extra copies of the writ petition be served on the learned CGC consulate and departmental counsel within 2 days. Let the relevant records be called for. Next. As there is inordinate delay in approaching the court, the prayer for bail shall be considered on receipt of the records of the tribunal. Next para. However, it is provided that in the event the petitioner is apprehended and taken into custody, he shall not be deported without order of the court. Next para. List on 8/1/2024.
Time being item 3 for motion. Time being item 5.
May I please, my lord? My lord,
Yes.
my lord, as per order of this court, my lord, 15/3/2023, my lord, I have filed an additional affidavit.
You have filed an affidavit.
I filed it on 28/10/2024. Regarding same and same person, into divine beliefs.
High Court order.
You make an inquiry of your own. In the meantime, we're issuing notice, and
Lordship.
notice is already issued.
Yes, Lordship. Lordship may hardly matter, Lordship, at length, because whether he is same person or not, it is
Okay.
it will be determined by
What's
Foreign
outside
Tribunal.
represented? The learned counsel for the petitioner submitted that an additional affidavit has been filed on 30/10/2024 pursuant to order dated 15/3/2023. In view of the same comma, as notice has already been issued by order dated 6/2/2019. The matter is admitted for hearing. List the matter for hearing in the month of January 2025 on a date to be fixed by the registry.
And my lord, in the meantime, my lord, she may be protected.
Pardon me?
She may be protected, my lord. In them is not there.
Next one. In the meantime, it is provided that the petitioner shall appear before the Superintendent of Police within bracket border, Borpeta, within 10 days from the date of the order. Punish a bail bond is 5,000 with one surety of like amount for the satisfaction of the said authority. Those conditions, as well as default condition that on non-appearance, the order of bail shall stand revoked. Public lapsed due to reflex of time. Next para. But this is already order to list it for hearing. It will be before that, this para.
Highly object.
Time being item 13. Time being item 13.
May it be please. Impun
Thirty.
opinion is at page 127, my lord. Opinion dated 38/2024.
127.
Yes. Final opinion is at 136.
We are giving you bail only because it's a recent opinion. But your witnesses are wonderful.
One aspect has also been taken plea in the Learned Court below that the referral authority has made an observation that the petitioner is an Indian citizen, not the foreigners. But that has taken in the written statement.
No, but the Supreme Court Police has they should must have must have discarded that,
Yes.
because if your own witnesses say what they have said, rightly so. Only a recent opinion, so we are giving you some protection. Heard Mr. R. Islam Dhanet, counsel for the petitioner. Also heard Ms. L. Devil and CCC appearing for respondent number 1. Mr. Ms. S.T. Khan, Dhanet, counseling on behalf of Ms. P. Barwa for respondent number 2. Mr. G. Sharma, Dhanet, standing counsel for the FT matters, representing respondent number 3, 4, and 5. And Mr. P. Sharma, an additional senior government advocate, appearing for respondent number 6. Filing this writ petition number so and so. Petitioner has assailed the opinion dated 30/8/2024, passed by so and so in FT case number so and so, arising out of police reference case number so and so, by which the petitioner was declared to be a foreigner of post 25/3/1971. Issue notice returnable in 4 weeks. Requisite extra copies of the petition be served on the CGC, Common State and Departmental Council within 2 days. That the relevant records be requisitioned from the concerned tribunal. The petitioner shall appear before the Superintendent of Police within bracket border, bracket was Dhubri, within 10 days from the date of the order. Bill 1 rupees 5,000 with one surety, with all those clauses as well as default clause of non-appearance. List after 4 weeks on receipt of tribunal records. 10 days to take bail.
Yes, sir. Much obliged.
Any Mr. Islam, any name in the neighborhood is left out?
Yes.
There's 6 alias. Any name left out in the locality? No. Okay.
Much obliged.
Item 22 for admission.
My lord, my friend is requesting me that I should appear in the case, my lord.
Definitely.
My lord, today, my lord, I have seen gone through the records.
petition, but I find that there are some lapses in the pleading. So, my lord, I may be allowed to file any additional affidavit, and matter may come up in the, my lord, next week, my lord. I will do in the next week. My lord.
Okay. Also, it's a represented. The prayer made by land council for the petition list after 2 weeks.
Right. My lord, I will also gone through the records with you. My lord, my prayer also prayer that I may be allowed to file an additional affidavit, my lord. Some lapses in the pleading, my lord, in the writ petition.
Oh, sure. See, Mr. A.R. Sigdar, Learned Counsel, appearing on behalf of, on instructions of Mr. A.S. Tapada, counsel for the petitioner. Praise for his granted liberty to file an additional affidavit in the matter.
Deeply obliged.
Item 23.
Lordship, we are on bail. My lord, may the matter be listed for hearing? My lord,
You see, last time a prayer for, on the prayer for adjournment, on the petition, the matter was adjourned.
senior is on legs.
Huh?
My senior is on legs in court.
Okay, after some time.
Item 24.
Jagat Chandra Bhai. None appears on call for the petitioner. So all the respondents are represented. So for ends of justice, the matter stands adjourned today. Is correct. Is make clear the petitioner remains unrepresented on the next date of listing. And my adverse orders may follow. List after 2 weeks.
Item 25.
Wait, please, your lordship. Lordship, I have the apology for seeking adjournment for 2 weeks, lordship. It's the first adjournment, lordship, after calling of the LCR, lordship.
Okay. Both sides are represented on the prayer made by land council for the petitioner. List after 2 weeks. Highly obliged.
Item 26.
Kindly wait. Kindly wait.
None appears on call for the petitioner. However, all the respondents are represented. So for ends of justice, the matter stands adjourned today. It is made clear if the petitioner remains absent on call on the next date of listing, adverse orders may follow. List after 2 weeks.
Respondent number 4 may be strike off, Lordship.
Just make a note and remind us on the next day. Today, the petitioner is not there. We don't want to pass an adverse
Yes,
order in
Lord.
the absence. You are right. It's not a necessary party, but still.
Item 27.
Same order. None appears. After 2 weeks. Last order, same, none appears on call. Same order.
Item 28.
Which page is the opinion?
Annex 4 will at page 24.
24. Mr. Rashid, you are aware of the observations made in the order dated 11/2/2019.
By this honorable court, my lord.
Yes, it is not complied with. Half of your case is gone. Now only 50% remains.
Only there is a to produce the voter list with along with. That order is not
That's why
with-
50% is gone, we are saying.
I'll try to, my lord, for.
Because the name does not match. And in the voters list of 2011, Johura, your wife, is not there.
Yes, my lord.
So it's different persons.
Because, my lord,
You're trying to connect with some voters list here and there.
No, I am not. My name is Mazul Ali Sheikh, and my father Miller, that is Sarvesh Ali Sheikh. And Mohan Bawa Miller, she is my mother. A serial number Miller. Yes.
You see, your villages are changing. You're not shown. Because that's why the query came up from the court.
My lord.
Earlier, you were in Sitakari part 1. Then you are in 121 Duramari. And therefore, the names are not matching. In your written statement, you don't say about the wife, Chaura.
I have that instruction that the Johura has expired. Thereafter, Miller, she.
No,
But
that
their explanation is not there. Yes, you are
It's
right.
not there in the written statement.
But their explanation is not
Now the
there.
wife changes. You see, not only the village changes, the wife also changes.
Wife not, no wife, Miller.
Yes, page 34.
Yes.
Now the wife is Mohiran Beva,
No, she is a mother, Miller.
mother.
Mother, Miller.
No.
She is 75 or so, Miller, and I am Miller 47. Sorry, Miller, mother. And my father name is Sarvesh Ali, and her husband name is the same, Miller, Sarvesh Ali.
Okay.
Not Miller. That is why, Miller, her name is not, my wife is no more. I have taken instruction from the client also, Miller. And by this time, Miller, the client, Miller, is it about 2017, she was Miller 51 years. So Miller another 5-6 years. So about Miller 56 or so. So at this time Miller she's his wife expired Miller, so there is no name. And village Miller, your lordship, earlier she was secretary 1 Miller, part 1. And subsequently Miller shifted to this. But district is Miller. District also similar. Yes, also same.
Districts are also different. Once it's Gwalpara, then it comes to Bongaigaon.
Oh, Golpara meaning your lordship already knows me. Earlier it was whole Golpara was now divided into 3 or 4 districts, my lord. One is Dhubri, one is Kokrajhar, one is Milord Bongaigaon, or yes, Bongaigaon. And another part is remaining as a Golpara. So 1970 or before, up to it is 84 or so, my lord, district has been, my lord, changed. Then it is, my lord, it becomes several parts, my lord. And another part, my lord, again, my lord, Mankeswar. So district, my lord, originally one, Golpara.
Who is Moiron Nessa?
Morin is a, my lord, mother.
Hmm?
Mother, my lord. And Sarvesh Ali is, my lord, father.
Where is her evidence?
Her evidence, my lord. 22, my lord. Yes.
Is there any voter list with of you with your parents?
My lord.
Which one?
Parent, my lord. Petitioner and father, 85, my lord. Page 30,
Page 30.
my lord. At the time, it was my secretary part 1, village. Now another village. Other things have same, my lord. Serial number, my lord, you are showing 166 and 170. 160 also. Father, mother, and he himself. At the time, he was only 21 years old. And in Miller page 31 also, Miller, that is Miller with wife. 32 also wife, Miller, with wife. And again, Miller, annex 10, Miller, page 33 with my mother. And page 34 also, Miller, same with my mother.
You have verified the records?
Lordship, earlier I have verified Lordship.
Okay.
If possible, Lordship may fix any date tomorrow, day
Take it
after.
up. If you have read it, then there's no issue. We'll take it up. There are one or two matters which are upgraded to. After that, we'll take it up.
My lord, item number 29, my lord. I'm led by Mr. D. Mazumdar, senior advocate in the matter. However, my lord, he is not available today in the court due to some personal difficulty.
That is, I think it's a habeas corpus matter.
Yes,
My
Mr.
lord.
Lordship, I am appearing as the petitioner.
I'm praying for a short accommodation, my lord. Maybe on Friday, maybe it is not
Friday,
possible
I'm
for
not
the
available,
petitioner.
Huh?
On Monday, my lords,
Because it's a habeas corpus,
My
we can't
lords.
delay this.
my lords. Mr. D. Mazumdar, senior advocate, he's appearing in the matter, my lord. Today, he has some personal difficulty, my lord.
When will be
Monday,
available?
my lords. Friday, it is difficult for
Friday,
the
I have
petitioner, I believe.
Then Monday?
Monday.
Monday, my lords.
Okay, but next time we'll have to do it. Habeas corpus, you can't
Yes.
just
Yes.
postpone
Lordship,
it.
actually, on the last occasion also, Mr. D not appeared. We actually fixed it on 27.
We have filed our affidavit
No,
otherwise,
no,
my lord.
that's not the issue. The issue is that once it is kept pending in the board, that causes us anxiety.
My lords.
If he is not
Okay.
available, Monday.
Monday, my lords.
29. Okay, also is a represented. Therefore, adjournment is made on behalf of Mr. D. Mazumdar, Learned Additional Advocate General. He's appearing as Additional Advocate General.
Yes, my lords.
Additional-
For respond number 1, 2, and 3.
Most of the prayer is allowed. This being a criminal repetition, list the matter on 20, sorry, this will be 2/12/2024.
212.
Okay.
Highly obliged. my lord.
That's much.
28.
This was the last matter we were taking up. Okay. All right. Okay. Both sides are represented on the prayer made by Land Council for the petition list after a week. Yes, item
31 minutes.
31.
Yes. Yes, my lord, the impugned order is at base, my lord, 55, my lord, ex parte order, my lord. In fact, my lord, the petitioner, my lord, is the son of on Hafizul Islam, Hafizul Haq, my lord, Hafizuddin, my lord, and some of the monument. Their names appeared in the voter list of 1965 as well as 1970, my lord. And the petitioner's name appeared along with his parents, my lord, in the voter list of 1975, my lord. Problem is that, my lord, after 2-3 dates, my lord, he did not appear before the Climate Tribunal, my lord. Hence, the impugned ex parte order has been passed, my lord.
Just wrong.
And pursuant to this order, my lord, he has been taken into custody, my lord.
No, you see, whatever has happened,
Yes.
but it's an opinion of 2019,
19, my lord.
then
Actually, my lord, I have stated in my paragraph numbers 24.
no,
onwards,
you
my
give an allegation against the lawyer. You don't give their
Actually-
names. You don't give, you don't make complaints against him.
lord. Yes, my
And in
lord.
2019, you had not even made a statement that you are paid to your lawyer. You see, why will a lawyer appear for someone without getting paid?
I have stated in my paragraph, my lord.
That is okay.
Yes, my lord.
But I just want to refresh my memory because when I was there at that point of time,
Yes, my lord.
I have certain memories. So please tell us.
Let's say, my lord.
Please tell me in the name of one lawyer who will appear without getting fees.
No, my lord, nobody will appear,
Then-
my lord. My lord, the duty of the advocate, my lord, he has to withdraw his Okaladam also, my lord. But that does not, he did, my lord. My humble submission, we will lordship, he will contest the case on merit, my lord, by submitting his written statement, my lord.
No, but you have not given any
He will face the
particulars.
trial.
Who was the lawyer? Whom did you?
Last
What
time-
is the reason thereafter not to contact the lawyer? You see, you engaged a lawyer. That is okay.
Yes,
2019 and now we are in 24. How many years? 5 years.
5 years.
5 years you'll have to demonstrate that you went to your lawyer. At least that much, that amount of,
That is the fault, my lord, of the petitioner,
Then-
my lord.
then
And
why
for-
should we release
for-
him?
For that fault, my lord, he has got the lesson, my lord. Today, my lord, 87 days, my lord. He is in
See-
custody, my lord.
but why we should release him?
Yes, my lord. He will contest the case, my lord, by filing his written statement, my lord. Otherwise, my lord, he has documents, my lord. For the ends of justice, my lord, he may be released on bail, my lord, and
was one good
a
document.
time frame may be given, my
It
lord.
was one good document which can connect you with your projected parents.
My lord, at voter list of 1975, my lord, which is at page, my
No,
lord.
except for voter list, don't show us the voter list.
Other
Voter
documents
list,
also, my
you
lord.
may have the voter list of the first citizen of the country. It's in public domain, you will get it.
In page 47 also, my lord, a certificate, my lord.
Page
Yes.
47.
Page 47, my lord. And my lord, 46 also, my lord, revenue records, my lord.
Just a moment.
This is at page 45, my lord. Serial number 3, my lord, Manzoor Islam.
Just a moment. We have seen something. We can't blame your lawyer at all. Your lawyer has asked the court that you better drop this proceeding. You recall the notice. Otherwise, the petitioner will be compelled to approach to seek remedy under Article 136.
Isn't it illiterate person, my lord?
No, illiterate, we don't know,
Yes, sir.
but it is your petition. You are telling the court if you don't do it.
Petition has been drafted by an advocate, my lord, and
No,
has been asked.
you are
to
just now
arbitration,
saying
my
that the
lord.
council did not do
Yes, my lord.
the needful, and blaming the council.
Yes.
Now this petitioner is referring to this 136.
Maybe, my lord, he's an illiterate person, my lord. He will
We don't
contest the
find any
case. my lord.
reason.
Otherwise,
We don't find any reason.
he cannot escape from the case, my lord. He will
But to-
contest the case.
But to give you bail.
85.
Time frame will be given, my lord. Within that time, my lord, he will file written statement, my lord.
Yes, Mr. Pine.
My lord, if your lordship considers on merit, my lord, there is no case at all because
Not on merit, but
yes.
only thing is that citizenship, if we can give an opportunity to the petitioner to contest.
yes, that is my lord.
At
One
cost
aspect.
of, that's by imposing some cost.
My lord, it is not that case, my lord, that he did not receive notice and he did not contest.
No, he was negligent.
Yes, yes, negligence, pure negligence is there, my lord.
Pure negligence is
So,
there, and for that he
my
has
lord-
got the lesser. level.
No, even on merit, you don't have a case. We have examined
I-
the, what is this?
up
We
to your
have,
lordship, my lord.
we are spending some time in
Had-
Yes.
appreciating the documents.
Yes.
The document itself indicates that there are two different families you are connecting with one.
Had you been
I leave it to
arrested,
your
my
lordship,
lord,
my lord.
you would not have come before this honorable court, my lord. Second part is, my lord, detention. My lord, in fact, what my submission is that so long actually I was not opposing this detention, my lord, releasing in bail. But, my lord, in such cases, my lord, my submission will be,
Because the record is here, there is nothing, no improvement.
yes,
Even by perusing of the record, nothing would happen.
yes. My lord, with regard to detention, my lord, the Honorable Apex Court in earlier occasions allowed those persons who has completed 2 years in detention camp. And this Honorable Court in numbers of cases allowed those who has completed 2 years of detention, my lord, if length of detention is counted, my lord. That was especially for the purpose of COVID period only, my lord, not on merit. So the releasing of, my lord, suspected foreigner is a not in bail. It's not a matter of case, my lord. It was only for the purpose of COVID-19 they were released during, my lord, 2020, my lord. Otherwise, they were never released, my lord.
Just.
Years.
Mr. Pang,
Yes.
what happens in the tribunal? Is the tribunal empowered to grant bail?
My lord, if he appears on filing his WS, my lord, he may grant bail. If satisfactorily the documents are found that satisfactorily, my lord, the tribunal can grant bail. Grant him on bail. My lord,
Huh?
that is the tribunal can grant him bail. That is the
Where
provision.
is that provision?
That is, my lord, 3 of the 1964 rules.
Huh?
Rule 3 of the, my lord, 1964 rules.
64.
Yes. That city of Boston. So, on his appearance.
6.
Yes.
6.
Yes, 6. দেখুন অবস্থা নাই।
Heard Mr. S. Islam, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned CGC, appearing for respondent number 1. Mr. H. Kuli, appearing on learned counsel appearing on behalf of Mr. A. Ali, standing counsel for respondent number 2. Mr. G. Sharma, learned, sorry, Mr. J. Pang, learned standing counsel for the FT matters representing respondent numbers
3, 4 and 6.
4 and 6. And Mr. H.K. Hazarika, learned government advocate, appearing for respondent number 5. Next one. By filing this petition under Article 226 of the Constitution of India, the petitioner has assumed the ex parte opinion dated 12/6/2019, passed by the learned member, Foreigners Tribunal 9th, Barpeta, in page number 55, in so-and-so, arising out of SP reference number so-and-so, thereby declaring the petitioner to be a foreigner of post 25/3/1971 stream. Accordingly, the reference was answered in the affirmative. Next para. The learned counsel for the petitioner has referred to the statements made in paragraph 24 to 26 of the writ petition to project that the petitioner had engaged a counsel to represent him, and a handsome amount of money was paid to the learned counsel. So, however, despite appearance and prayers made for adjournment for filing written statement, the written statement was not filed. So it is also projected that the engaged counsel assured the petitioner that he will do the needful and assured him that he would give the information to him about the fate of his case. It is further projected that on 2/9/2024, the police arrived at his house and arrested him, and thereafter he has been, the petitioner has been shifted to the transit camp, Matia, Goalpara. Accordingly, comment is submitted that the proceedings against the petitioner, which proceeded ex parte, was not within his knowledge. First off, it is also submitted that the petitioner has sufficient documents to show that he is not a foreigner from Bangladesh, but he is a citizen of the country. First off, hence, the counsel for the petitioner prays for sitting aside the impugned ex parte opinion dated 12/6/2019. To grant the petitioner an opportunity to contest the proceedings and for grant of bail to the petitioner in the meanwhile. Next paragraph. The learned standing counsel for the FT matters has opposed the prayer for interference with the ex parte opinion of the learned tribunal, as well as in respect of the prayer for bail, on the ground that the tribunal had served notice of the proceedings to the petitioner And instead of filing a written statement, comma, the petitioner had sought adjournment on 5/11/2018. Comma, which is the date of his first appearance. And on his prayer, on his petition filed on 5/12/2018, the matter was again adjourned. Thereafter, the petitioner had filed further petitions on 4/1/2019 as well as on 19/1/2019. And though the matter was adjourned, comma, the petitioner had stopped appearing before the learned tribunal and the ex parte opinion was rendered.
15 to 2 years. Oh, 15 to 2.
Hmm?
15 to 2 total 10 years.
Is absent on just correct me, Nabil. And thereafter he was absent on and from 5/2/2019.
7/3 2019. Five to 15 to
15/2/2019. 7/3/2019. 29/4/2019. 14/9/2019. 14/5/2019. 3/6/2019. Thereafter, ex parte opinion was rendered on 12/6/2019. Accordingly, it is summarized that the learned tribunal had given sufficient opportunity to the petitioner to contest the reference. Accordingly, he also opposes the prayer for bail. Next paragraph. Considered the submissions made by the learned counsel for both sides. Also peruse the records received from the learned tribunal, comma, which was called for by by order dated 23/9/2024. Pursuant to which the same was produced by the learned standing counsel for the FT matters. Next paragraph. Insofar as the notice is concerned, it is seen that the notice of the proceedings were duly served on the petitioner, and the petitioner appeared and filed petitions on 4 occasions, but did not file a written statement. First of all, in the absence of any complaint against the learned counsel engaged by the petitioner, we cannot find fault with anyone except the petitioner who had not taken steps in the matter. Full stop. Therefore, on merit, the petitioner has not been able to make out a case to show that he was not negligent in the in appearance in the proceedings before the learned tribunal. Next para, however, comma, as important right of citizenship is the issue before this court. Citizens of the petitioners before this court, comma, the court is of the considered opinion that at least one last opportunity be granted to the petitioner to file his written statement to contest the proceedings. Full stop. Accordingly, without finding fault with the manner in which the proceedings was taken up by the learned learned member, comma, Foreigners Tribunal, 9th, Borpeta, comma, the impugned opinion dated, ex parte opinion dated 12/9/2019 is interfered with, setting it aside only for the purpose of granting one opportunity to the petitioner to file his written statement positively. Within the time allowed by this court or so extended by the learned tribunal. Next para. In order to compel the appearance of the petitioner before the learned tribunal, comma, the court is not inclined to grant bail to the petitioner as full stop. Nonetheless, comma, as the proceedings of within bracket BPT bracket close case number 817 of 2000. Sorry, number is FT 9th within bracket BPT bracket close case number 817 of 2018, comma, arising out of SP reference IM within bracket D bracket close T case number 966/D/98 is restored back to the file of the learned member, comma, Foreigners Tribunal 9th, comma, Borpeta, comma, we deem it appropriate that the Superintendent of Police within bracket border, Borpeta, shall within 3 days from the date of receipt of a certified copy of the order produce the petitioner before the said learned tribunal post of on such production, comma, the learned tribunal will fix a date, preferably within 2 weeks, for filing of the written statement by the petitioner. We just say, correctly to say that we grant, how much time you need for written statement?
20 days, my lord.
20 days.
Yes.
Okay, we grant 3 weeks time from today for the petitioner to file his written statement before the that learned member, Foreigners Tribunal 9th, Borpeta. Full stop. It is provided that the Mr. Payak, I always forget, it is the jailer of transit camp, or what is the designation?
That maybe superintendent.
Superintendent of transit camp, superintendent of transit camp, Matia Borpeta.
Gwalpara, my lord.
Huh?
Gwalpara.
Gwalpara shall authenticate the signature of the petitioner on the written statement. Full stop. On the date when the written statement is proposed to be filed, shall be intimated to the Superintendent of Police within bracket border, Borpeta, would make arrangement for the conveyance of the conveyance and production of the petitioner before the learned member from Foreign Tribunal 9th Borpeta. Full stop. Next para. On such appearance of the petitioner before the learned tribunal, comma, it would be open to the petitioner to apply for bail, and the learned member from a Foreigners Tribunal 9th Borpeta shall consider the same, the prayer for bail in terms of paragraph 3 within bracket numerical 5 bracket closed, again within bracket numerical 6 of the foreigners within bracket tribunals bracket close order, 1964, and dispose of the bail application in accordance with law. Next para. It is also provided that before the production of the petitioner before the learned tribunal, the Superintendent of Police within bracket border, Borpeta, shall do the needful for capturing the biometrics of the iris of the eyes and those conditions. Okay. Next, but accordingly, this according to the writ petition stands allowed on the terms that is indicated above, that the records of the tribunal be expeditiously sent back. Bail prayer before them.
The learned member will consider the same, bail prayer, my lord.
You have
And
provided for that.
Before filing the written statement, he has to intimate the jailer of the detention camp, my lord.
You'll have to tell them when to be produced.
Yes.
Suppose your written statement is ready today, you tell the SP border, they will take you to that.
He has to intimate the SP border.
Yes, because SP border is the authority to make movement of the persons who are detained under his jurisdiction.
Yes, madam. He will communicate the same.
He will produce.
Yes, madam. Oblige.
Upgraded item 32.
Yes.
May I please, Lordship, my lord? Lordship will kindly have a look at the impugn order, page 57, 58, my lord, annexure 8, my lord. Here in this case, my lord, the petitioner is the, my lord, elder brother, my lord. In another case, I have also annexed, my lord. On the basis of same sort of documents, my lord, his younger brother was declared to be an Indian citizen by the same member, my lord. And regarding the voter list of 1965, my lord, which I produced, my lord, that was exhibit 1. Only single name, my lord, voter list was there. That was in the name of my grandfather, my lord. I have annexed, my lord, both the voter list of 1965, which was exhibited by me as well as by my younger brother, my lord. If my lord kindly turn to page, my lord, 18, my lord. That is the voter list of 1965, which was produced by me, my lord. Pertaining the year 1965, the name of my grandfather is reflected in it, Jafar Ali.
My lord, nowhere in the WS and evidence lordship, Pro City has stated that he has a brother and A case is pending
sure.
before the concerned Foreigners Tribunal, Lordship.
And produce it.
Where is the written statement?
My lord will find it. Page 48, my lord.
48.
Yes, please. Annexure 6. My lord. Name of all family members were incorporated, although the reference was against the petitioner only. My lord. Page 49, my lord's operative portion, so far as the case of the petitioner is concerned. My lord. Paragraph number 11, my lord, page 49. Starts with.
No, we are just searching for that statement where you have introduced your brother.
Yes, my lord.
Your brother, Mr. Sharma says is not introduced. Is
He
it
has been
there or it is
introduced in
not?
the evidence, my lord.
Huh?
In the evidence also, my lord, he has been introduced as brother. In the evidence.
But your brother did not come and deposed.
He did not come, since he has also, my lord, faced one proceeding, my lord, separate proceeding, but the same exhibits were, my lord, relied upon by the younger brother of the petitioner, my lord. In his case, my lord, in his brother's case, my lord, the voter list pertaining to the year 1997, where his younger brother's name appeared along with the parents, my lord, that was relied upon by the same member of the tribunal. Whereas, my lord, I also, my lord, exhibited the same voter list pertaining to the year 1989, my lord, where my name also appeared along with my parents' blood. That was not relied upon. My lord. I have annexed, my lord.
Where is the written statement of your brother?
The brother's written statement I have not annexed, my lord, but the judgment I have annexed.
No,
my lord.
because your brother
Final order.
might have denied your existence at all.
My lord, from the, my lord, perusal, my lord, lordship will kindly
No,
peruse.
we are looking at a document.
Yes, my lord.
Please understand, we are looking at thousands of documents
Yes.
where there's a lot of difference
My lord.
of names of villages. So
Yes.
how do we know that what is the exact document which has been
That I
examined?
also, my lord, annexed, my lord, in this petition also, my lord.
Have you called for that proceedings?
No, Lordship.
No, my lord, but if your lordship, my lord, kindly allow me, my lord, 2 minutes time, my lord. Lordship, this
Yes,
will be
yes.
very clear, my lord. From the exhibited, my lord, annexed documents, my lord, I have annexed the voter list along with the land documents also, my lord. Where my name along with my brother also, my lord, appeared, my lord. We have inherited land from our father, my lord.
Where is that?
Yes, my lord. That land document, my lord, will kindly, my lord. Page 41 is the vernacular, my lord. Annexure number 3, my lord. 41.
41.
Yes, my lord. Vernacular. Serial number 6, my lord, in the left side, my lord. My name appears at serial number 6, Hussein Ali, and my younger brother, my lord, at serial number 7, Idris Ali.
Page 41.
41, my lord.
Which is your
My name appears at serial number 6, my lord, Hussein Ali.
number 6?
Yes. Hussein Ali, and father is Ajit Ali, my father.
What was the exhibit number?
Exhibit was,
Number.
yes, my lord. That was not exhibited, my lord. That was exhibited in the other case, my lord, the younger brother's
Again
case.
and again, we have been asking the council not
Yes.
to rely upon a document which is not exhibited before the tribunal.
My lord. But if your lordship.
Yesterday, we were indicating that every time you indicate to a document
My lord.
which was not exhibited, then cost will be imposed.
Lord, I will clarify it. My lord. Lordship will kindly allow me some time.
No,
because-
clarification
No,
is
we-
different.
Why that? Why we should not dismiss it and ask you to present a petition which is proper? Mr. K. K. Parashar, run as CGC for respondent number 1. Mr. G. Sharma, run as negotiate for FT matters representing respondent number 2, 3, and 6. And Mr. H. Kudi on behalf of Mr. A. I. Ali for respondent number 4. And Mr. H. K. Hazarika, run as government advocate appearing for respondent number 5. Then that paragraph. Huh? Just one. Next paragraph. The petitioner shall file. The petitioner and or his learned counsel shall file an affidavit to clarify which of the documents annexed to this writ petition are not exhibited documents. If such an affidavit is not filed, or writ petition would be liable to be dismissed on the ground that that an attempt has been made to mislead the court. Next paragraph. As the petitioner is relying on the opinion opinion dated 29/5/2024 passed by the learned member from Foreigners Tribunal 3rd, Morigao, in case number FT 74 of 2016, page 61. When the court is inclined to call for the records of the said FT case, of the case number FT 74 of 2016 from the member, Foreigners Tribunal number 3rd, Morigao. So the registry shall make a requisition for the said records. Next paragraph. List after 2 weeks on a date to be fixed by the registry. We file an affidavit in the meanwhile.
My lord, the only prayer is that if your lordship kindly fix the date, my lord, that will be convenient to us.
No, we can fix it tomorrow, but you tell us when you will be filing it.
I'll file, my lord, within Monday, my lord.
Mathematics 6th December 2024.
I'm deeply obliged.
The second record may also have to come. The second record.
Pardon me?
By 6, whether the record should come. Okay, that will.
No, certainly, examine. No, not 6, make it 9th.
Yes.
Okay,
The
you're making it
record
9th, records may not come. Okay.
Upgraded item 36.
May please the lordship.
In this case, I have received detailed instruction, my lord, and everything has been followed, my lord. Here, the impin order of 14/5. It is executed on 24/5/24, and the Hindi translated copy were supplied to the detainee on 28/5. That is after 4 days. Within 4 days of
There's a
detention.
copy. You have a copy of that?
My lord, that instruction only have, my lord.
Pass it on.
My lord. Thanks. Just I have flag mark, my lord. This is a parawise just that figure. And subsequently, as per the advisory, state advisory committee, my lord, given the consent, and it is now confirmed.
It's okay. Because we'll need the dates
My
of
lord.
when the petitioner was arrested, when he was informed of the grounds, when he
yes.
submitted a representation.
Yes.
To whom did you send those representations?
Yes, my lord.
Those are there. We're just trying to find out the.
My lord, on the 24/5 executed.
Just a moment. Where is your representation
My lordship will find it
of 13-6?
13/6/20.
Where is that?
37, man,
37.
of my writ petition.
What is the date when you handed it over?
My lord, page 47, it's 13/6/2024.
13-6.
13/6/24. Instruction.
Executive Procedure 24/5. Rejected on 21/6.
Yeah, 24.
No, rejected on
Or rejected.
21/6/20.
21/6 by
21/6, matlab, it is rejected, matlab,
Retaining
page
authority.
53.
central government on 18/7.
All the competent authorities, including the central
Sec-
government,
Yes,
as well as by the authorities under the NDPS or
Matlab, yes, central government,
Central
this
government.
procedure has been done by the central government, and after the advisory committee of the state, taking the opinion of the state advisory committee, matlab, just confirm.
what is the date of confirmation of?
Confirmation, matlab, on 16/7/24. Page 54 of the petition itself, matlab. And after confirmation, matlab, 16/7/24, they have approved the honorable court only on 21st of October. Confirm on 16/7/24.
Then how much time you will file your affidavit?
Affidavit within 3 weeks, matlab.
No, 3 weeks is too long.
Matlab,
Sir,
I will by tomorrow itself, I will sell by mail, matlab, and they have to 2 weeks, matlab.
because
And in this
once
case,
it's the
matlab,
habeas
everything,
corpus,
Not everything, my lord,
in habeas
because
corpus, we
Yes,
are
yes.
bound by the time.
yes, matlab, but matlab, they have, matlab, it's confirmed on 16/7/24, and they have approved the honorable court on October.
no, my lord, because page
No,
55, I have
you
annexed.
forget about those
Yes,
things.
yes, matlab.
But in a habeas corpus,
No, madam,
whatever, right or wrong,
Yes.
we have to dispose of it in a town band manner.
Matlab.
My lord, detaining authority rejected on 21/6. Then, my
No,
lord,
but you see, we have to have an affidavit by
my
the
lordship, my lord,
union, that is important,
my lord. Central
Because you-
government on 18/7/24, my
because you can't proceed on a,
instruction. My lord.
without an affidavit, if
Matlab,
we pass an order,
My lordship,
please tell us, Mr. Das, supposing we reject your petition, then what would happen?
my lordship.
Then you will say that,
I'm not pressing for my
no,
lord,
not that, but
Yes, sir.
then you will say that you have not been given an
My
opportunity to
lordship.
contest it.
my lordship.
There lies the difficulty.
That is why I asked my learned friend also whether you have filed an
No,
affidavit.
yes,
with respect
I'll
to-
file my.
We understand that,
My
but
lord,
make it 10 days. Ask them, because it's a habeas corpus, they know when it is
Matlab, I'll try my best.
preventive detention. But Mr. M.K. Das, learned counsel for the petitioner. Mr. Next para, Mr. K.K. Parashar, learned CGC, has produced a copy of written instructions received, instructions dated 12/11/2024. And he submits that he has received the, as he has received the Paravise comments, he may be granted 2 weeks time to file an affidavit in opposition in the matter. Full stop. Next, considering that this is a habeas corpus petition, timely disposal is necessary, the court is inclined to grant time, 10 days time to the respondents to file their affidavit in opposition. Full stop. So that the said affidavit be filed by 9/12/2024, list on 10/12/2024.
Deeply approved.
Mr. Das, one more thing. We are asking you because there may be something in the affidavit which you would like to respond. You need the time. We list it on 10th, or we list it on any other day if you want to file a response.
My lord, can it be after 2 days, my lord? No, 12. 12, my lord.
12th, okay. Filed by 9th. Stop. Reply, if any, by the petitioner will be filed within 2 days thereafter. So list on 12/12/2024.
Deeply approved.
Because then there will be less,
Yes, my lord.
what do you call, passing of time.
My lord.
Otherwise, again, we give you time, we'll get it listed again. It'll
Right.
take more time.
My lord.
That's why we're asking you.
My lord. I highly appreciate. My lord.
You take back your instructions.
Item 23.
Sorry, my lord, I was on spot number 22.
Just a moment. Mr. Chaudhary, why is income tax doing, what is income tax doing here?
Lordship, in fact, I had made a mention in court number 1, but then it is an order passed by Justice Kaushik Goswami. Therefore, perhaps it has been placed here. He is in court number 1.
Oh, okay, we understand. We were just thinking and suddenly I recognized that you are sitting here.
Oh, that is,
It's okay. It's okay. I was intrigued, therefore I asked. Okay. This way. Yes.
My lord, in this case, I am on bail. And the case, so far, if your lordship hears, my submission would be only, my lord, it is a case of remand in the view that only one witness was examined. And I asked her and she said that I was not asked to adduce any evidence.
Incidentally, both my brother and I have passed judgments where I have said only one witness is good enough for conviction. Both my brother and
True.
you both pass orders.
Otherwise, my lord, I might have a good case because there are linked
On the
cases.
basis of one evidence,
Only
they are
one
convicted,
evidence.
gain life.
Only the petitioner adduced evidence and did not adduce any other witness. And so far the case is concerned, lordship may kindly see exhibit 1.
Mr. Mahmood, please tell us. Let us say a hypothetical situation. We are not asking about your case. It's an hypothetical situation where a man has picked up few voter list of few documents from here and there and presented. And therefore, none of his projected family members come and depose. It can be that also.
I am not denying that, but
she said that actually she has persons who can reduce in her favor, and the documents are also with her. So, your lordship.
No, I'll tell you that very simple. I am good in giving horrible examples.
Yes.
I am giving you one. You see, when you are standing for the petitioner and I'm asking you questions, you will say that the judge is horrible. Correct. I'm just giving a hypothetical situation. I'm not saying you are doing it, but let us say for an example. But you tell us that you are asking questions, you are horrible. And then I turn back to Mr. Sharma here and ask him that, how am I? He's likely to say that I am good.
Good. Yes.
Prosecution has examined one witness, resulted in acquittal. State has come in appeal, saying that now we'll adduce 10 more prosecution witnesses. You are in the defense. What would be your submission?
Definitely, I will oppose that. But here is, my lord, the burden of proof is like civil case. No, criminal
No,
case.
it is not a indefinite
Yes, sir. I understand that.
line of witnesses. You have to be it has to be definite.
We are not drawing inference. We are just asking questions. We have not yet drawn inference.
I have verified the record. There are 2 or 3 orders are there that the petitioner did not come with witness. I think 2 or 3, not more than that. After WS, so however, because I have the document since 1951, madam. 51, 66, 70, 70, and land allotment order in my father's name by the government. That is also there.
Land allotment.
23.
Pass. হ্যাঁ? Communication করেছে। করেছে? কোনটি?
এটা হলো কমিউনিকেশন করেছে। এই যে ব্যবহারী বানানো।
নাই। কাগজটো পাইছো স্যার। পিটিশনৰ কপি এটা দিলে ভাল হয়। পিটিশনৰ কপি দিয়া নাই, অকল হেৰিটো দিছে।
অকল সেইটোৱে দিব গৈছে। সেইটোৱে দিব
বক্স এটা নেই।
অবশ্যই লাগিব।
টেবুলতে থৈছো।
Lord, I have also brought some decisions
Yes, yes.
and order is expertise because she did not appear. After appearing, she filed WS, but then disappeared. So of course, tribunal had no option but to proceed on. But here, Lordship may kindly see page 17. Page 17, that is the NRC of 1951. And in 1951, here Mokshed Ali is my grandfather.
Just a moment. Mr. Mahmood, we find something else. You see, you have consulted the records of the tribunal.
I have seen the order sheets.
You see, we are looking at the evidence which you have filed. And these are photocopies. All exhibits are photocopies. Now, despite your evidence being closed in the previous date, you made a prayer and you filed your evidence, and that was accepted. But all the documents are photocopies. Therefore, if there was no cross-examination, it was the state who is aggrieved. You could not have been an aggrieved person if you are not cross-examined, because then your evidence goes into the record. But you have submitted photocopies only. There was no prayer to give the original documents. You did not give an original document and you were there. See, you have flagged it for you, page 41. So therefore, you have no case at all. And then comes another thing. To send it back to allow you to adduce further evidence would be to cover up the lacuna.
My lord, my submission is these are exhibited, several documents are exhibited.
No document is exhibited, all photocopies.
No,
Just-
no, my lord.
Just give it to you.
51, exhibit 1.
That's the
Exhibited.
difficulty, you're not,
Now whether
you're not.
it is rightly or wrongly exhibited, that is another matter, but tribunal exhibited this.
No. Tribunal has rightly put into record that it's a photocopies, therefore rejected. You say you have seen the order sheet, even in the order sheet it is mentioned that they have only filed photocopies.
Here, my lord, first page, NRC, exhibit 1, NRC 51. NRC 51, my lord. That is exhibit 1. What are the 66 exhibit 2? Kindly see page
No.
11 of the.
Mr. Mahmood, we can tell you things as it is. We are not arguing, we are not arguing with you. We are just telling you the facts. Your evidence was closed. Your evidence came on record on 13/1. On 13/1, you filed photocopies.
It is here, photographic documents are not admissible in evidence in law. That is there, but my lord, one thing, my lord, may I
Look at
submit?
the order sheet of 13/1. No, you have to turn this way. You have to turn it like this.
13,
13/1,
131.
13 January. Penultimate order.
Yes. Copy is present and submitted evidence on affidavit along with photocopy, hard argument, documents.
789.
Documents exhibit
7, 8, and
9.
7, 8, 9.
Exhibit 7, 8, and 9.
Exhibit 7, 8, and 9. So, my lord, it is there that she.
So the court has accepted it. The tribunal has accepted the documents as it is. But if the documents are not admissible, then rejected it. It is within the parameters of order 18, rule 4 proviso.
For one thing, my lord, if something, there is a citation of Honorable Supreme Court that any objection regarding any document.
The court is not objecting to it. Why should somebody object? The document itself is you see, there are two things, Mr. Mahmood. Number one is the manner of proof and second is the mode of proof.
Yeah.
So the Supreme Court has never said that a photocopy, even if not objected to, becomes admissible.
Singh said that if any objection is there, that should be
Objection
made
as to
at the
admissibility.
first instance.
Objection as to admissibility. But you are forgetting something.
Acceptability to read into the evidence. But whatever is not admissible in law, Supreme Court has never said, I think, subject to correction, of course.
Supreme Court said that any objection regarding any document shall have to be made at the first instance,
No.
not thereafter.
No. It can't be. Because that judgment must be read along with order 18. It shows this judgment which you are referring.
Yeah.
There are two kinds of objection. One is regarding irregularity and one is inadmissibility. So, so far as first kind of objection is concerned, if it is not, objection is not raised at the first point of time when the document was produced and sought to be exhibited, then that objection cannot be raised at a later point of time. But so far as inadmissibility of the document is concerned, that can be raised at any point of time up to.
That is no point. Yes, that is no point. No point may be raised, yes. But I have in my memory clearly that any objection regarding any document should be passed at the earliest point of time. Otherwise, my lord, yes, I have got. 2004, 12 SCC 360.
2004, 12 SCC
360. Para 1112. Name of the Food Corporation of India versus Assam State Cooperative Marketing and Consumer Federation Limited. Here it is any objection regarding a document must be at trial stage, not thereafter. So my only humble prayer is this.
That's why I'll tell you, this judgment we have read, I have just text I would not recollect.
Para 11 and 12.
Will tell you something. Because of this admissibility, I can give you more than 10 judgments.
No, that is true. What by learned friend, that's true. And by learned, just say correct. Admissibility of the documents, that is the primary condition. But thing is, these are very poor as well as illiterate people. So they are not properly guided many times.
So that we don't know, we call the learned, counsel always learned. In none of my orders, I have said that he is not a learned counsel. But yes, I have got.
Otherwise, I can produce all the original documents of this, but he did not compare it. Before submitting, he should have been compared this. Party is not supposed to know all this. So if
Yes, now we'll tell you what has happened here. In this case, it was a kharif crop which was sought to be purchased by the Food Corporation of India.
Yes.
And this was a transaction of kharif season 1975-76. So an advance was paid and about 2 crore rupees was paid in the year 1976 within 1 month time, spread over from 16 to 1976 to 27 to 76. And then the supply of paddy was to the extent of rupees 1 crore 60 lakh. So for the remaining money which is not, for which the kharif crop was not provided, for that the FCI came and filed a suit. And therefore it was claiming rupees 7 lakh 3,000 which is given in advance. Now the cause of action is of 20 September 1976. And the suit of 39 lakhs 36,810 was filed. Correct. Now the issue of limitation is after a year, about 7 months time within the next year, when the limitation will fall. And it is at that stage that the document Exhibit 7 given by the defendant was exhibited. Correct. Now we are at a time which is prior to 2001. If you have the CPC, you just give it to him. By virtue of amendment made in the year 2001, you see Order 18 Rule 4 now. Order 18:1 says that the evidence will be by an affidavit. 4 says you,
Yes, my lord.
Yes.
Recording of evidence.
4,
Yes, order 18,
rule
rule
4.
4, my lord. I am reading 4. In every case, the examination in chief of a witness shall be on affidavit, and copies thereof shall be supplied to the opposite party by the party who calls him for evidence, provided that where documents are filed and the parties rely upon the documents, the proof and admissibility of such documents which are filed along with affidavit shall be subject to the orders of the court.
Correct. So this is what proviso says. So when an evidence on affidavit is filed, nobody raises dispute with regard to the documents. In a writ petition, when you file a writ petition, whether the document is a manufactured document or a real document, we don't know. So when the other side appears, then only they will say that this is a fake document which is produced before the court. So admissibility of a document, you see, again read the word admissibility.
Yes, that admissibility
Correct.
of such documents are filed along with the affidavit shall be subject to the orders of the court.
So it is admissibility.
Yes.
So later on, if it comes that this is only a document which is a photocopy, it is not admissible and it's rejected. What is wrong? You are relying on a judgment which is prior to the amendment in the CPC. So in CPC earlier, when there was a oral evidence, and when oral evidence was there, the other side would have to be very cautious, and therefore you will always find that lawyers who have practiced prior to 2001 in civil side
Yes.
would be far better than the lawyers now
Yes.
concentrating on a civil practice. Earlier, being a plaintiff was a difficult task. Now becoming a defendant is a difficult task. So there's a shift.
The time schedule, time bound is there.
Now that's why you are relying on a judgment which is not applicable now, because we have we can say at least 10 judgments.
I was on simply on principles of law. That was
My brother immediately remembered one Roman Catholic Church. It's a Kerala decision. That is one. The admissibility, there's a lot of, even I have authored orders where the admissibility is subject to further orders of the court, and therefore, if it's a
My lord,
just not
kindly
admissible.
give me one chance and let me go through after the amendments, what are the things with whether I can get something in favor of the client. Kindly adjourn the matter today, my lord. Because I have no option, because definitely what your lordships have got, that is a real question. After amendment, something is changed, that change I have, but the law which I have read is 2004. 2004, I am earlier than 4. So that may kindly you can let me go through whether I can satisfy your lordships in a better manner or not.
Because you have touched upon something where my brother has a larger trial court experience than me. So
Very critical. In criminal matters, my Lord Justice Chaudhary is very much critical.
no, both sides.
I argue to one case, every point he gets.
Both sides, vast experience. That's why we are saying.
Yes, yes. So that's why I was very much cautious to appear in his court. I am telling my open.
Mahmood, I am still learning. I am a student of law only. Subject to correction always.
No, Mr. Mahmood, we will not accept that. Because you see, if you were cautious in appearing before my esteemed brother, you would have taken very good care to look at the records, even consider the trial court records and then admit us.
Yes.
It means you thought that you could fly away.
Let me go through it.
Okay. Both sides are represented on the prayer made by Mr. M. U. Mahmood, the counsel for the petitioner. List after week.
Let it be 2 weeks, my lord. I have some
2 weeks.
personal difficulties.
Okay.
Last week. Last week, yes, yes.
Mr. Chaudhary, we'll update your matter.
Obliged.
Because we have no time for others.
Item 30.
Actually, this matter.
It will take us quite some time to travel from foreigners to income tax. FGHI. So, yes, what is the point here?
It would be primarily revolving around the interpretation of section
Okay,
131A.
Mr. Dr. Saraf is not there?
In fact, on the earlier occasion, Dr. Saraf appeared. I don't see him today.
His appearance is recorded in the last date.
In the last order, his name is recorded. Lordship.
Is he aware of the listing of the matter? 30.
I have not seen him today. Perhaps maybe he's come in a different bench, so he has maybe listed out. But otherwise, normally
Change हो सकती
he
है.
calls me up if
जी दत्ता राय पर मिलता है उसे. हाँ. डॉक्टर We pick it up next week, then you please inform him.
I will inform him, Lordship.
But what you are saying, we did not hear you. What you are saying?
Lordship, perhaps, Lordship, since this is not a regular bench to take up this matter, maybe it has escaped his notice. Otherwise, normally it would have come up before court number 1.
No, it's okay, but. Huh.
If it is not inconvenient for the court, Lordship, may I pray that if it is on the next week, if it can be on Wednesday, Lordship, because Monday.
It can be done that Dr. Saraf's name be reflected in the respondent side in the cause list.
It's a question of non-production of the records after 6 years, which led to the assessment.
Lordship.
And then the
No,
court.
but there was a search. There was a search. And
Yes.
the petitioner has challenged the search on the question of prior notice under section 131A. So court has proceeded on that line. Now, your lordship has to interpret the provisions of section 131A and 132 because the search was under 132. My contention before your lordship is that a prior notice was not required.
131A,
Yes, lordship.
that is search and seizure.
Search and seizure is 132.
Okay. Income Tax Act. I just refresh my memory. It is.
Yes, yes, yes. 131, 1A and 132.
I have completely forgotten. Oh, discovery and production.
Yes, lordship.
Okay.
So there was a search and the petitioner's side took a plea that if your lordship will come to 131, 1A, if the principal director general or director general or principal director or joint director or assistant director or deputy director or the authorized officer referred to in subsection 1 of section 132 before he takes action under clauses 1 to 5 of that subsection has reason to suspect that any income has been concealed or is likely to be concealed by any person or class of persons within his jurisdiction, then for the purposes of making any inquiry or investigation relating thereto, it shall be competent for him to exercise the power conferred under subsection 1 on the income tax authorities referred to in that subsection, notwithstanding that no proceedings with respect to such person or class of persons are pending before him or any other income tax authority. So this is the
No,
bone
but-
of contention, lordship.
No, but this C. Just reading it again.
Yes,
The
lordship.
assistant director so-and-so officer referred to in subsection 1 of section 132 before he takes
Yes.
action against clauses 1 to 4
Yes.
of that subsection.
Yes,
1 to 4,
of 132.
132
Yes,
is to enter such a building.
yes. Now I'll have to satisfy your lordship that a notice issued after that search.
No, but how is this to be read?
Lordship,
130
that is-
132
that is
says,
that is what I will be emphasizing, lordship. Lordship will see.
no, 132 says 1. Thereafter there is small ABC. Then
Yes,
comes, after that there is a then.
yes, lordship.
Then capital A, B, C,
Yes,
and then 1, 2, 2, 8, 3.
this will be, lordship, the after B.
Just a moment. Subsection 1 of section 32. I feel this section is 1 to 4 of that section. Section 1 of the 4, and it will be C. Then particularly. Then P. Then 1 to 1 to 2 of subsection 1. It causes P. 1 to 3. You have the Income Tax Act with you.
Yes, lordship.
132, 1.
Yes,
Then comes small ABC.
yes, lordship.
Then comes capital ABC.
Lordship.
After that, there is a then.
Then,
1, 2, 3, 4.
yes, lordship.
So how do we read that? That provision will be read as a clause to 131, 1, or it will be a clause to 131, 1
It will be, lordship, after B.
C.
After B. It will be after them, because enter and such.
So 1 small a, 1A, or 1 small b, A, like that. Because we're just interpreting the provision.
Lordship.
So what would be the correct way of reading it? 132, 1, 1, or 132, 1A, 1, or 132, 1B, 1.
No, A, B.
AB.
Lordship, if we read the middle portion of 131, 1A, then.
No, we're just putting that question.
Yes, I do
You
understand,
respond to it
lordship.
because
I do understand, lordship.
after 2 weeks I may forget, but please remember to address us on how to read this
Yes.
provision. How this clause is to be read. 132 or 131, 1 A, B, C, then 1, how it is to be read. Okay.
Because lordship, it see, here it states.
So they are perhaps taking a plea that you asked me for discovery of a document which is past 6 years and therefore.
No. Lordship, in this case, a search and seizure process was over under 132.
Yes.
Thereafter, the deputy director has issued a summons. So the contention of the petitioner before the learned single judge was that the summons has to be issued first, and only thereafter you can go for search and seizure. That is the bone of contention which the learned single judge has upheld. So my endeavor before your lordship will be that this summons need not be issued before, because if I issue the summons, the person will hide everything. There will be no question of any search and seizure. So in that line,
Yes.
lordship, I will try to emphasize.
Unless he is like us, no place to hide.
Lordship cannot hide.
Okay, so that is the only question
That
to be
is the-
answered.
That is the question.
Okay, at least we get an idea of what is
I
there.
impress upon your lordship that these summons are not required to be issued prior to this, because this amendment has come in later on. I think it should have come in 132, but somehow or other it has come in 131.
Okay, we just
Lordship.
wanted to have an idea because
Yes.
income tax is now foreign to us.
No, lordship has done so many.
No, it is foreign to us now.
Now,
Okay. Mr. RKT Chaudhary, Learned DSGI is present. Mr. Howard, there is no representation from the respondents. Mr. For ensure justice, the matter stands adjourned today. Next para. The registry shall reflect the name of Dr. A.K. Saraf, Senior Counsel, for the respondent while listening the matter next. Along with his instructing counsel already on record.
lordship, if I may pray, it can be taken up on next Wednesday, lordship.
Hmm?
If it can be taken up on next Wednesday, lordship. Now, if it is not inconvenient for the court.
Fourth. Okay, 4/12.
So-
List on 4/12/2024.
Because Monday there will be an NIA matter, it will be a longish matter, lordship.